Good morning and welcome to another edition of the Senate Committee on Commerce and Labor. Madam Secretary, please call the roll.
Senator Buck. Here. Senator Daly. Here. Senator Hammond. Senator Lang. Here. Senator Pazina. Present. Senator Scheibel. Senator Stone. Here. Chair Spearman.
Here, and please mark the other members present as they arrive. Today we have 3 bill hearings, Assembly Bill 23, 27, and 39. Want to take a little bit of time to go over some basics, and I'll say this twice. If you have anything that's going to ring or anything that's going to sound like a door slamming, please shut it off or put it on mute so it doesn't go off during testimony. Those of you who are here by this time, you know that there are at least 4 ways that you can participate here in Carson and Las Vegas. You can, excuse me, you can write a letter or you can submit your opinion online at the on the Nevada Legislature webpage. Please, 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 when you testify, turn your microphone on and make sure you speak clearly, project your voice. Some people listening to us over the internet, if you don't project your voice, then they cannot hear you. So please, please, please project your voice. And remember, when you finish testifying, please turn your microphone off. Also, a reminder to those who testify pursuant to Nevada Revised Statute 218E.085, it is unlawful for a person to knowingly misrepresent facts when they testify before a legislative committee. And myself or any member of the committee can ask you for documentation to prove your points. So with that, please turn your phones off and we will get started. Margie, good morning. Assembly Bill 23. Revised version. Measure revises provisions relating to the resolution of certain administrative citations issued by the State Contractors Board. Welcome. And just before we begin, I want to say this. You know, we went through some pretty rough times during COVID, before and after, and I just want to commend you and your staff. You all did a stellar job. So thank you. Thank you for your service to the state. Thank you.
Thank you very much. Mm-hmm. Thank you and good morning, Chair Spearman and members of the committee. My name is Margie Green, that's M-A-R-G-I-G-R-E-I-N, and I'm the Executive Officer for the Nevada State Contractors Board. With me today I have Dave Behar, who is our Director of Investigations, and also in Las Vegas I have our Board Counsel, Noah Allison. So they are both testifying on behalf of the board today. So I'm here today to testify in support of Assembly Bill 23, which expands the existing process for the resolution of an administrative citation to allow individuals the opportunity to request an informal conference with the executive officer or his or her designee for the purpose of reviewing the alleged offense and proposed penalty. Between fiscal years 2020 and 22, a total of 1,173 administrative citations were issued to both licensed and unlicensed contractors. Approximately 5% of those resulted in contested cases. Currently, NRS 624 does not provide a process for which an individual can seek an informal resolution or settlement. Pursuant to NRS 624351, the board is required to hold a formal disciplinary proceeding should a person choose to contest any portion of an administrative citation. Under Assembly Bill 23, individuals who receive an administrative citation by the board would have 15 days to request the informal conference if desired. The requested conference must be scheduled within the following 60 business days by the executive officer or a designee. Resolution of the citation may be agreed upon during the conference, including affirmation, modification, or dismissal of the allegations. Should the citation be modified or affirmed, an individual would still have the right to contest the citation formally within 15 business days by requesting a hearing pursuant to 624345. It is anticipated that this process proposed by AB 23 will reduce the current number of contested administrative citations that are adjudicated through the formal hearing process, as well as reduce costs incurred by the board, as well as the respondents in the cases. Based on discussions with interested parties, the bill was amended in the Assembly to include a provision that any hearing required by these provisions must be held within 90 days of receiving a written notice of intent to contest the citation. This amendment will ensure timely resolution of these matters. And with that, I'm happy to answer any questions, or I can turn it over to our Director of Investigations.
Committee members? Yeah, Senator Daly?
Thank you, Madam Chair. Margie, good to see you. So as you know, I had a few questions, and we talked about some of this stuff before session started. And I do think this is a step in the right direction. I think it's a good process, at least to start with. But when someone contests, so your normal process, you send them out the citation, you ask them for additional information, or do you send out a letter and say, hey, we've had a complaint, send us this information. And then you have a typical process and you have a non-typical process. So can you remind me of what the normal process is? And then this would be interjected in only if they get a citation, correct?
Thank you. Chair Spearman, may I go directly to Senator Daly?
Yes, please, please.
Thank you. Yes, Senator Daly, currently our process is that we investigate the case. There's an investigation that takes place prior to the citation. At the end of the investigation, if it's determined that there are violations that can be resolved through an administrative citation, normally in those cases, there's not a harmed party. Or there's something that can't be resolved between the two parties, so the administrative citation would be issued. Currently, and one of the problems with that process is there is no appeal process at that particular time for the respondent to contest the citation rather than go to a hearing. So this new process puts something in place where if they contest it, then they can request a formal meeting with myself or my designee, and we'll go through those charges, and they may have evidence at that time that disputes or refutes the information that we are charging them with. So this will be a way to resolve it prior to the hearing.
And that's what I understood. I know you try to involve the contractor and whoever filed the complaint, if that's the case, in trying to do that. But that doesn't always happen where the contractor gets to provide the information other than in a statement. Doesn't get to go to the job, doesn't get to contact or interact with the complainant. So in this process, are you also intending to have the person who filed the complaint in the process as well, or is it just the contractor?
Thank you, Margie Green, for the record. At this point, when it gets to the citation process, it's only the contractor at that point, or the respondent, that gets to come in for the informal conference. We don't bring the other party back in at that point.
So when I look at the process, so I'm looking at this and thinking it's more of a settlement conference type of situation. If you were looking at like in the court system, or a pre-hearing conference, if you will. I know that's a term that's used with the labor commissioner on some of the stuff before you go to a hearing. And at those conferences, and I don't see the language in here, and I think it needs to be added, is that confidential is not the right word, but they should not be recorded. People should be able open and fair. Anything that may have been said or can't be used in a following proceeding if you don't come to settlement. You have to give them that notice on all of that information there. And then I think that both sides should be present myself, but I think everybody has to put their evidence on the table. So you guys would have to show what information you have so that they can fully explain, if not, and let go from there. Do you guys object to having those type of parameters, or is that what you already intended? Because if you're going to go to this conference and then you're going to try to say something that's going to be used against you later, it's not going to work.
Thank you, Margie Green, for the record. I would like to ask our counsel, Noah Allison in Las Vegas, if he could respond to that since it's more of a legal nature.
Yeah, thank you, and good morning. For the record, Noah Allison, counsel for the Nevada State Contractors Board. Mr. Senator, I envision it the same way you do, as a settlement conference that is akin to a mediation statement settlement conference in the court, where the judge can order that. And of course, as in under all of mediation rules, nothing that's said in a mediation can be used later. An admission or anything like that can be used to support the allegations made later. So I agree that's the way it should be with these informal settlement conferences.
Well, I would think that, thank you, Madam Chair. I would think that we would need to lay that out and specify it. And I know the language I looked up is from an area of law that I was familiar with is Administrative Code 607-300 regarding pre-hearing conferences with the Labor Commissioner. And it spells out, can't be recorded, no information there can be used in a subsequent proceeding, and that both sides have to bring their evidence and put their cards on the table in order to try to get a settlement. And I think at the minimum that needs to be added into this, otherwise it is not going to work.
Margie Green for the record. Senator, we're happy to look into that for you.
Senator Stone?
Thank you, Madam Chair. My colleague was alluding to an issue that I had with regarding exculpatory evidence and shouldn't be recorded. And I know that's the intent of the bill, but I hope that, per my colleagues' request, that there is language that is written that anything discussed in this mediation cannot be used in a discovery kind of process to go forward if a settlement can't be made. But I just want to say that I support the concept of what you're doing. I think it's very business friendly to bring people in when they have their violations. In this informal process, is there ever a recommendation to the contractor that their license is going to be suspended or revoked, or is that reserved for the full board?
Thank you, Margie Green for the record. That would be reserved for the hearing. We cannot do that in a settlement or pre-conference.
You know, just like in my profession of pharmacy, there's a lot of complex laws, and sometimes you inadvertently, do something that you didn't think about, and you get cited for it, and it's nice to have an avenue where you're not putting somebody before an entire board and having to hire an attorney potentially. If you can settle it in a amicable way, I think it's just a business-friendly attitude towards business, and I applaud you for bringing this type of bill forward with hopefully the protections that have been so articulated. Thank you.
Thank you. Any other presenters?
Good morning, Chair Spearman and members of the committee. As the Director of Investigations for the...
Give me your name.
Pardon me. Sorry, David Behar for the record. As the Director of Investigations for the Nevada State Contractors Board, I believe this newly implemented process would streamline the ability of our staff and contractors to resolve these ongoing matters more timelier and more efficiently, while also providing a remedy to members of the industry to have that matter heard in more of an informal setting, which would allow that possible resolution we just briefly discussed, and also, more importantly, the avoidance of unnecessary fees and costs. Thank you.
Senator Daly?
Thank you, Madam Chair. And you said the one last part there about unnecessary fees and costs on various things. So in my experience, what I had recently with the Contractors Board, so if a person exercises this right to have this pre-hearing conference, is it typical for the board, if a person gets a citation and contests it, that you guys then request a bunch of other information from the contractor without any other probable cause? You just basically create another penalty for exercising your right? Are you guys going to try to do that with this? And I think that was wrong to do it the other way. And if my colleagues don't understand is, so if a person puts in a contest and says, hey, I think you're wrong, you haven't showed me any evidence, you don't show it until 15 days before the hearing when it's requested, so they can't get it once they got the citation. But you do send them a letter, a contractor, who's just exercising his rights. It says, hey, well, we want you to audit your books and go out and spend 3 times what the citation might be worth if you're going to have a hearing. And I think that's an unfair disadvantage to the contractor. And I know not every contractor is a saint, but not every person filing a complaint is a saint either. So I think that's just an unfair penalty, and that would not be imposed on this, and I think it should be taken away on the other part unless you have additional predicate to ask for that. So you're not going to do it on this, are you?
David Behar for the record. That was one of the purposes behind this bill, was to avoid that process and to streamline it so there wouldn't be the additional costs that sometimes are applied when it ends up going to a hearing.
Thank you. With that, if you want to step back, and we'll open up the hearing for public comment. Anyone in favor of Assembly Bill 23, please come to the table. Here in Carson City, anyone in favor in Las Vegas? Don't see anyone coming. Yes, we'll start up here in Carson.
Good morning, Chair Spearman and members of the committee. Chase Whittemore with Argentum Partners today representing Nevada Builders Alliance. We are in support of this bill, and Senator Daley, Senator Stone, I think we'd be even more in support with those changes that Senator Daley mentioned. I think that would make a lot of sense to ensure that nothing is recorded and people can present evidence and not have that fear. You'll have a better discussion and probably a better outcome. So would be happy to work with the Contractors Board on that additional language for sure. Thank you.
Lindsay Knox with McDonald Crono here on behalf of the Nevada Home Builders Association, the Southern Nevada Home Builders Association, and the Builders Association of Northern Nevada. We believe that the enforcement of Chapter 624 is important to the integrity of the construction industry. This bill will help provide some efficiency that will allow the Contractors Board to do their job, and I think we also agree with Senator Daley's suggestion to the amendment. Thank you.
Hello, my name is Sarah Collins. I am with I3 Public Affairs with the National Electrical Contractors Association of Northern Nevada. We also want to state our opinion that we are in support of this bill. Thank you.
Anyone else? Don't see anyone moving to the table in Las Vegas. BPS, anyone on the phones?
The public line is open and working. There are no callers at this time.
Thank you. We'll move now to those in opposition. Opposition here in Carson. Don't see anyone moving to the table in Las Vegas. BPS, anyone on the phones?
The public line is open and working. There are no callers at this time.
Thank you. So we'll move now to neutral here in Carson, Las Vegas. No movement. BPS, anyone on the phones?
The public line is open and working. There are no callers at this time.
Thank you. Ms. Green, you want to come back up and close out?
Thank you, Chair Spearman and members of the committee for allowing me to present this bill today, and we look forward to working on a possible amendment. Thank you.
Thank you. And with that, we will close the hearing on Assembly Bill 23 and open the hearing on Assembly Bill 27, revises provisions relating to contractors who provide management and counseling services on construction projects.
Thank you. Good morning, Chair Spearman, members of the committee. Margie Green for the record. I'm the Executive Officer of the Nevada State Contractors Board. I have also with me today Dave Behar, Director of Investigations, and Noah Allison, Board Counsel. I'm here today to testify in support of Assembly Bill 27, which seeks to amend the language in NRS 624215 as it relates to construction management and counseling services. This bill is primarily housekeeping in nature and is intended to ensure that a construction manager is properly licensed and skilled for the type of construction project covered by the contract. The lack of specificity in the current language, which was passed in 2019, was questioned by an administrative law judge in a disciplinary proceeding and resulted in a decision that a licensee holding any one of the general building classifications could act as a construction manager on any type of construction project. I believe a copy of that decision and order was submitted as an exhibit. Under this ruling, it is feasible that someone holding a license classified for pre-manufactured housing or residential remodeling with only these limited skill sets would be permitted to act as a construction manager on the construction of a high-rise hotel casino or other significant complex projects. It is clear that the decision poses a significant health and safety risk to the public. This amendment would remedy the unintended consequences and ensure that the work is only performed by licensees with the proper qualifications and skill set based upon the scope of work of the project. Thank you again, and I'm happy to answer any questions. And some of these may be of a legal nature, so perhaps Noah Allison would be better to answer questions on some of those, but I'm happy to take any questions.
Thank you. Committee, questions? Senator Daley?
Sorry, Madam Chair. Thank you. And I am familiar with this. I believe the complaint that resulted in that decision was put in when I was working at the laborers union. So my simple question is, do you think this is going to solve that particular problem? And I'm hoping so.
Margie Green for the record, and the simple answer is yes.
Additional questions? Okay. All right, if you step back, we'll open up the public hearing on Assembly Bill 27. Anyone here in Carson City in support? Anyone in Las Vegas in support? Good morning.
Good morning. I'm Craig Madole, the CEO of the Nevada chapter of the Associated General Contractors. We think that we agree with Ms. Green. We think that this is good clarification of law, and we also believe that if you're going to be managing any construction type, you should be licensed appropriately.
Good morning, Chair Spearman, members of the committee. Chase Whittemore for the record, Argentum Partners, today representing Nevada Builders Alliance, and agree with Mr. Madole and would like to thank Ms. Grimmer and the Contractors Board for meeting with us and answering all of our questions. Thank you.
Hello, Sarah Collins with Nika North. We supported this legislation in the other house, and we are here to support it again. Thank you.
Okay. I don't see anyone down south. Nobody's on the phone, so we'll move now to opposition. Assembly Bill 27. Anyone in opposition? No one's moving here in Carson City. Don't see anyone moving in Las Vegas. No callers. And no callers, so we'll move now to those who are in neutral. Wow, we should have had you here 3 weeks ago. Okay, I don't see anyone coming up in neutral. Ms. Green, you want to come back and close out?
Thank you, Chair Spearman, members of the committee. Thank you for allowing us to present this bill, and we believe it will clarify a problem that we didn't really see coming until just this couple of years. So thank you again.
Thank you. With that, we'll close the hearing on Assembly Bill 27 and open the hearing on Assembly Bill 39. Revises provisions relating to contracts for work concerning certain residential improvements. This is Margie Green Day, right?
Thank you, and good morning, Chair Spearman, members of the committee. My name is Margie Green, Executive Officer for the Nevada State Contractors Board. With me today is Dave Behar, Director of Investigations, and in Southern Nevada, we have Noah Allison, Board Counsel. I'm here today to testify in support of Assembly Bill 39, which aims to strengthen protection for consumers looking to contract for certain residential improvements. Residential contractors are most relied upon by the consumers we serve. They are the ones that we invite into our homes, who we call in our time of need, and who help to restore our environment when disaster strikes or make needed and planned improvements. It is because of the variety of contracted works to sustain a home that the contractors believe consumers deserve to have standard contract expectations that guide their best interests and ensure the contract is enforceable for both parties. A common trend noticed among the complaints filed with our office is validation of overpayment. Whether too large of a down payment was made, up to 50% of the contract price, or payments exceed the amount of work completed. We know most homeowners would benefit from specific contract terms guaranteeing important project details are defined and agreed upon up front. To illustrate, between fiscal years 2018-19 and 21-22, the Contractors Board validated 135 complaints of contractors accepting money when little or no work was performed, resulting in damages to residential homeowners in excess of $1 million. I think it's important to note that these are only representative of the homeowners who have chosen to contact the board with their concerns. AB 39 speaks on behalf of all homeowners facing these circumstances and offers them protection from becoming our next statistic. Following the investigative process, eligible consumers have access to the Residential Recovery Fund. Created by the legislature and enacted into law into 1999, the Recovery Fund provides monetary relief to qualified homeowners the board finds financially harmed by licensed residential contractors. Each of the 135 cases I referenced had their claims heard by the Recovery Fund Committee, and a total of $1,057,707 was awarded upon validating the financial harm incurred. This award alarmingly represents 32% of the total amount awarded to homeowners from the Recovery Fund during that same period. The Contractors Board favors the new requirements proposed in AB 39, which will establish contract terms such as limiting initial down payments or deposits not to exceed $1,000 or 10% of the aggregate contract price, whichever is less, or providing for a consumer protection bond. Documenting the estimated date of completion, writing a description of work to be performed under the contract and any change orders incorporated, progress payment requirements, and specifying the total amount to be paid for the work performed under the contract. AB 39's provisions provide necessary safeguards that enhance consumer protection while reducing the gray area often caused by miscommunication and poor contracting practices. The Contractors Board finds the language specific to residential improvement projects to be sufficient and appropriate, given that enhanced statutory requirements for work concerning residential photovoltaic systems and contracting for residential pools and spas already exists in Nevada law. These areas of the construction industry were addressed and improved following similar rises in complaints with concerning trends. In the 1990s, we noticed increase in pool construction complaints, and again in 2020 when solar contracting issues trended upwards. Just as we have experienced in both pool and solar industries, once contracting requirements were standardized, the industry responded to the new heightened accountability by fulfilling the new statutory expectations. It is our belief that AB 39 will have the same outcome, and we will begin to see a noticeable decrease in the complaints filed with the board against licensed contractors who took down payments from homeowners without performing any work or providing any materials. AB 39 is a win for consumer protection in Nevada, but it is also an opportunity to standardize contracting for Nevada contractors, affording businesses of all sizes to have confidence in the work they are engaging in. Thank you, and at this time, I'd like to turn it over to Dave Behar unless you have specific questions for me.
Ms. Behar, and we'll take questions after that.
Good morning, Chair Spearman, members of the committee. Dave Behar for the record. I'm here today to provide testimony in support of Assembly Bill 39, which aims to strengthen protections for consumers looking to contract for certain residential improvements. As the Director of Investigations for the Nevada State Contractors Board, it's my responsibility to continuously work towards protecting the health, safety, and welfare of the public while assuring licensed contractors throughout the state are treated fairly and equitably. An important aspect of this responsibility involves proactively working with the public and members of the industry to provide consumer protections that are practical and effective for everyone. Too often, cases have been brought before the board that involve homeowners who pay significant down payments for work that are either partially completed or completely abandoned. Frequently, these harmed homeowners are left with significant financial losses and dire conditions at their residences. Based on these circumstances, AB 39 would significantly safeguard consumers and members of the industry by providing protection to both parties. I'd like to highlight a few examples of why the board is seeking your support for this bill. An investigation in northern Nevada identified a licensed contractor who took over $380,000 in contract deposits from more than 38 different homeowners without performing work. During the investigation, it was revealed that once the funds were received, they were being diverted for personal use and past debts that had been incurred by this licensed contractor. Although the contractor subsequently lost their license by having it revoked, the widespread financial losses associated with that activity impacted a significant number of consumers. A second example involved 36 homeowners who were harmed by a licensed contractor who did little to no work after receiving payment. In this instance, more than $321,000 was collected by a contractor who abandoned the work and diverted the money as well. This licensed contractor ultimately had 3 separate licenses revoked by the board, but forced homeowners to endure lengthy and incomplete delays on their projects and remedy through the board's residential recovery fund. Finally, a third example involved over 20 homeowners who hired a licensed contractor to fabricate and install security screens at their residence. Each of these homeowners paid up to 50% in down payments prior to any work being performed. During the investigation, the licensed contractor received funds from consumers and abandoned work once payments were received. The board revoked that license and worked with victims to once again help them provide recourse to the agency's residential recovery fund. To emphasize the severity of this issue, between 2021 and 2022 alone, 85 separate residential recovery fund claims were brought before the board involving money that were taken by licensed contractors by homeowners without any work being performed. These claims alone totaled over $767,000 that ended up being awarded through the Residential Recovery Fund. We look forward to working with other members of the industry and concerned parties regarding this bill. Thank you.
Thank you. Questions? Senator Daly?
Thank you, Madam Chair. And I guess I'm just trying to read this and have a few concerns. When a contractor gets licensed and they're new within the first 2-3 years, aren't they already required as a condition of their license to put up a bond to the Contractors Board?
Thank you, Margie Green, for the record. Yes.
And then do you guys figure out how much that is? Is it different for everybody? Is it just one sum?
Margie Green, for the record. Thank you, Senator Daly. It depends on the monetary license limit issued to that contractor.
And then after a period of time, if a contractor has performed well or done whatever, they can put in a request so that they don't have to have that bond. It takes 2 or 3 years to be in business before the board allows that. Is that correct?
Margie Green, for the record. Yes, Senator Daly, that is correct. They can apply to be relieved of the bond requirement.
And I did a little checking when I read on this on how much it would be, and I understand that there's an if in there, so take the smaller amount as the down payment, otherwise then you don't have to put this $100,000 bond. So is the $100,000 in addition to the bond you already asked them to put down?
Yes, Margie Green, for the record. Yes, Senator Daly, that would allow a provision where a contractor could put up a special $100,000 consumer protection bond solely for consumers, and that would relieve them of the requirement of the initial down payment if they wanted to charge a different amount, down payment amount, rather than the $10,000 or 10% or $1,000 that's currently in the law. They could waive that by providing a consumer protection bond.
And then would they have to get a bond for each particular project, or would it be one that covers all of the work they do?
Margie Green, for the record, it would be one bond.
One bond. And like I said, I did some checking with some contractors that I know, smaller ones. So it would be $2,000 to get a $100,000 bond if you have good credit. If you don't, or you're brand new or whatever, it's $3,000 to $5,000. So it is a cost, and I think it could be a barrier. Separate question, you don't have to answer. It wasn't really a question. I'm just saying that it can be prohibitive for some small and startup contractors. But I do have a question over the language about a contract being voidable. And I've looked through your law, 624, very lengthy, complex, moves this section to that section, if this, then you go here. Same thing with your regulations. So the way it says now is that if you violate any of those, that the owner, and there are bad people who hire contractors, start looking for loopholes and don't want to pay, so they file a complaint, various things. So the contract is voidable if you missed anything, right? And I just don't know that that's going to work. I think the guy should have to be paid for the work he's done before it gets voided. I'm fine with voiding it, but if work's already been done, there's material that's bought. I don't think a homeowner should be able to try to enrich himself because somebody missed a period on that stuff. And I've seen that done. People get into contracts and they don't want to pay, so they file a complaint rather than paying. And the only recourse the contractor may have is to file a lien to get the homeowner to pay.
Thank you, Senator Daley. And Senator Spearman, or Chair Spearman, could I ask our legal counsel to respond to this since it's a contract issue?
Sure.
Thank you. Good morning, Noah Allison, Board Counsel for the record. Mr. Senator, I'm looking at the language of the statute, and with respect to the comment made about it being voidable, I'll read it into the record. It says, with respect to a contract executed before October 1, 2023, if any schedule of payments set forth in the contract does not comply with the provisions of this chapter or any regulations adopted pursuant thereto, the obligation of the owner to make payments in accordance with the payment schedule is voidable. What I think that means is that if you have a contract, if you're presented with a contract that has a, for instance, a schedule that requires you to pay a 50% down payment in it, or something that does not comply with the law, it means that the homeowner can void that, that section of the contract is voidable. I do think that the right to restitution and equitable compensation for work actually performed is not affected by making the contract voidable. It would just simply render that section voidable.
And I appreciate that, but let me read to you in section 1, starting on line 12. It says, a contract that does not comply with the provisions of this section and all applicable regulations adopted by the board is voidable by the owner of the single-family residence. No other conditions, just voidable if you miss something. That's in section 1, starting on line 12.
Good morning, Noah Allison for the record. Yes, I do see that, and I do believe, though, that the intent of that section is not to prevent the the contractor from recovering payment in the event the contract is deficient. Again, it's our hope that this statute leads to the development of a uniform model contract for this area. But if it is deficient in that area, it's voidable. But voidable, in my opinion, under the law, does not render the obligation to be paid for your work void or impossible to recover for that work. It just means that you walk into court in a restitution posture, meaning the fair value of the work that you've performed.
And if I can follow up, Madam Chair. And I appreciate that, and you've heard me say this before. I understand the intent, and I didn't hear the word judge behind your name there, so you don't get to decide. But I understand what the intent is, but that is not what the words say. So if I'm a homeowner and I want to do this, and I have that words right there, and I find out, even after the work's done, before I've paid them, that, hey, they didn't follow a regulation, they missed it. I can say, here's the contract, voided, and that's it, right? That's what it says I can do. It says I can void the contract. So the only obligation that the owner has to pay the contractor is through that contract. And if that contract is voided, the obligation is voided with it. So I think there needs to be some changes there. And contractor board should, if they're going to go this far, should provide some model language for people to use to say, hey, if you use this deal, you're going to be in compliance. Give everybody some safety. But I think you're going to have nothing but problems. And it's my experience with some homeowners that they will do that. And then the final thing I got, if you want, I think is over the definition of a contract. You say that it has to be in writing. And then I believe in sub 7, it just says any contract can be voided. I says, and there's a conflict there with, and you're the lawyer, right? But contracts can be oral. They don't have to all be written. So you need to say, hey, contract, oral contracts are not applicable in this deal. And I understand that people should get to changes and change orders and all of this stuff in writing, but that doesn't always happen either. So.
Noah Allison, for the record. Thank you for those comments, Mr. Senator. I do agree with much of what you said. I think that the intent of this statute and is that these things will be in writing. These contracts will be in writing and should be in writing and must be in writing. Just by the language of the statute throughout appears to require that, and that's the direction, and that certainly is the direction in the interest of the public and health, safety, and welfare that this needs to go. We don't want to see verbal contracts with residential improvements. We want to have something in writing to protect both the homeowner and the contractor with some very basic information, such as what are you going to do for me, how much is it going to cost, how long is it going to take. Those items need to be in writing.
I don't disagree. They should be, and maybe you need to put language in that if the contractor doesn't do it, he's assuming that risk, and force him to put it in writing. But and I understand the intent again, but we need to make sure the words match the intent.
Additional questions? So thank you. We're going to check and see how, with our legal folks, and see how that can be tightened up. That's okay with you? Okay. So we step back. We will now open public hearing in support of Assembly Bill 39. See anyone in Carson City? Someone's coming to the table in Las Vegas. Let's begin when you're ready.
Thank you, and good morning, Chair Spearman and members of the committee. My name is Paul Rosario, and I'm the former Director of Investigations for the Nevada State Contractors Board. And I'm here to testify today in support of Assembly Bill 39. Over the past 4 fiscal years, the board had seen a significant increase of complaints from homeowners who paid down payments to contractors as much as 50% in some cases and did not receive any work or materials. It appeared that some contractors who were on the verge of business closing took on a number of contracts with large down payments with the anticipation of closing their doors. Some were so brazen that they sent out notifications to homeowners advising them to file claims against the Residential Recovery Fund to receive their down payments back. Some contractors took several $100,000 from homeowners, knowing they would never start the construction projects. These actions by the contractor resulted in over $1.2 million paid out to homeowners from the Residential Recovery Fund, a fund that has limited resources. I believe that unless legislative action is taken to limit down payments, the Residential Recovery Fund may be severely reduced and in jeopardy. AB 39 provides requirements for residential improvement contracts, such as providing an estimated date of completion for all work to be performed under the contract, a description of the work to be performed under the contract and change orders, and the total amount to be paid by the homeowner for work to be performed under the contract. Additionally, AB 39 only allows any initial down payment or deposit paid to the contractor to not exceed $1,000 or 10% of the aggregate contract price, whichever is less. This is an important element of the legislation which provides some financial safeguards for homeowners. AB 39 will help provide a more standardized contracting practice within the residential improvement industry, allowing the board to hold the industry more accountable and ensuring consumers are treated fairly by contractors. And at this time, I'd like to answer any questions if you have any.
Seeing no questions? Thank you, sir. Anyone else? Anyone else in support? See someone moving to the table?
Yeah, we do have one more person coming up here, Chairman.
Okay, and if there's anyone else in Las Vegas, come on and occupy the chairs now. I don't see anyone here in Carson City. Yes, ma'am, begin when you're ready.
My name is Marilu Thomas. I'm 89 years old. I've been a resident of Nevada since 1954 and a homeowner since 1966. In February of 2022, I noticed a leak in my house, called a plumber that I had used for small jobs before, and he, after assessing the problem, informed me that I needed new pipes inside and out of my house. He charged me $24,000, for which I had to take out I had to refinance my home to pay him. I was told that I would pay half down and half in 2 weeks when supposedly the job was to be finished. This necessitated my son and I to move into a converted garage, which fortunately had a small bath that wasn't affected. After he received his money, things slowed down. I finally realized that I could call my insurance company. They advised me, when they found out what happened, they advised me to contact the contractors board, which I did, thank God. They have been a lifesaver to me. I found out at that time that the plumber had lost his license that January. It's now 14 months. My house has been a shambles ever since. My son and I are still living in the garage, but hopefully, thanks to the Nevada Contractors Board, there's light at the end of the tunnel. And I can't thank them enough for what they've done for me. If you have any questions, I'll be glad to answer them.
Committee. Thank you, ma'am. And so glad you're going to get your house finished. I don't know what to say. Sorry for your trouble. There's always a ticket going south for people who do that, though. So anyway. A special ticket. No calls. All right. So we'll move now to Carson City. Anyone in opposition? Anyone in Las Vegas? And no calls. Move to anyone neutral? And anyone in Las Vegas as well? Yes, please.
Good morning, Craig Madole with the Nevada Chapter AGC again. We submitted an amendment for the committee's consideration that would partially address some of what Senator Daley had asked. I do want to point out that we made a typo on the amendment. It should be referencing NRS 624, not the mortuary statute. That it's our intent here that, as Mr. Daley described, if a contractor is no longer required to post a bond to the contractors board, they would also be exempt from this provision of law, not requiring them to post this $100,000 bond. These are the established contractors that have proven financial strength. They've been in business for a minimum of 5 years pursuant to this section of law, and we think that this would be good clarification and try to keep the costs down, because anytime you increase costs on a contractor, they just have to pass that cost on to the homeowner. So if anybody has any questions on the amendment, I'd be happy to answer them.
Thank you.
Good morning, Chair Spearman again, Chase Whittemore, Argenta Partners, representing Nevada Builders Alliance, and we're neutral. There's a lot of intent behind this bill is good. Obviously, like the woman down in Las Vegas was testifying to, strengthening, I think this bill will strengthen and help improve the residential recovery fund, stabilize that fund. So that's a great thing. There are some concerns, I think, around the voidability language, and pains me to say this again, but I agree completely with Senator Daley. But yeah, I think you could address those pretty easily if you had a standardized form created by the Contractors Board, and we've had those discussions with them. I think that is their intent, to have a standardized form. That would be super helpful, I think, for the industry. And then if, say, for instance, if you didn't use that standardized form, then maybe the contract, then the homeowner could then void the contract. Just an idea, but again, yeah, we are in neutral. Thank you.
See no one coming forward in Carson City, no one else coming forward, no one in Las Vegas, and anyone on the phones? Okay, no one on the phones. Ms. Green, you want to come back? I just had a couple of, and I went to your website and I saw the answer to one, but you have there the admonition that if the person is over 60, it's enhanced penalties. Talk about what that might look like, and I want to use the lady, the homeowner who came up forward, it's 89. What does that look like?
Thank you, Margie Green, for the record. Yes, there are enhanced penalties for for senior citizens and for disabled and other circumstances, if it's a repeat offender, et cetera. But in Ms. Thomas's case, we did revoke the contractor. Unfortunately, she is one of the hundreds of people that we see every year that this has happened to. It tears at us every day, the number that increases on the rise. With regard to the amendment from Associated General Contractors Nevada chapter, we are neutral on that amendment. We don't feel that that it's going to change the bill's intent with that amendment. There's approximately 4% of the contractors have been relieved of the bonding requirement as it is, so we don't feel that amendment will harm the intent of the bill, so we are neutral on that. But again, I urge you to consider all of your constituents throughout the state that are dealing with this on a daily basis. Thank you.
Next question. As Thomas said, she's been 14 months, so is there a statute of limitations on this? No?
Margie Green, for the record. Could you clarify that question?
Yeah, and I'm just thinking, so the person who did this to her, I think she said she's been living in a garage for 14 months, and so she's filed a complaint. Is there a statute of limitations that if she were to wait like 3 years and whatever, so?
Thank you. Margie Green, for the record. Thank you for that clarification. It's 4 years from the time that the work occurred. That contractor that she is referred to has since been revoked. He also had other cases in Southern Nevada where he did the same type of thing to other victims as well.
And on your forms you have, it's a criminal complaint, so you all work with the AG's office and the DA's office on these issues?
Thank you, Margie Green, for the record. Yes, we do work with outside authorities when the charges are such that we can bring form criminal cases or criminal charges in addition to administrative charges.
I think this is the last question. So a lot of times what happens, and I watch these shows like Holmes Makes It Right, and, we go to the rescue or something like that. So sometimes they move from state to state. Do we have anything in place where we cooperate with other states that if there's someone here that loses their license or they've been found guilty in a criminal complaint, if they move to California, Montana, or something like that, is there any type of a database that would follow them, or is it just kind of catch as can? And the same would be a requirement here. Someone who from another state came in and they applied for a license, but they've already, done some pretty horrible things in other states.
Thank you, Senator Spearman. Yes, we do have reciprocity on disciplinary actions, and that is on a national basis. There also is a data bank through NASCLA, which is the National Association of State Contractor Licensing Agencies, where we enter that information about contractors who have had discipline in this state. And again, we don't want contractors from another state who are disciplined coming here. We do an extensive background research on that, and there is reciprocity with that. However, what we do see a lot happening is a lot of these contractors prefer to move to Texas because there's no contractor licensing in Texas.
Okay, thank you. Ready? All right, with that, we will close the hearing on Assembly Bill 39, and we'll open it up now for public comment. And a reminder, public comment limited to 2 minutes, and it does not address anything that we've already covered in any of the other bills. Is there anyone here or in Las Vegas for public comment? See anyone moving? Okay. And so with that, we will prepare to adjourn this edition, and we'll see right back here on Wednesday at 8 o'clock. Thank you. We're adjourned.